I welcome you all to the CEC Gurukul live lectures. We have been discussing about the intellectual property issues, and in the previous lecture we discussed about the Industrial Designs Act. I gave the preliminary overview about the Industrial Designs Act. I also discussed in detail the subject matter for the Industrial Designs Act or for the design protection under the Industrial Designs Act. We have seen that a shape, a configuration, composition, figure, lines, shape of goods, these things can be protected as industrial designs under the Industrial Designs Act, and a copyright in design gets conferred on a design if it is applied to an article. These are certain things that we have dealt in detail in the previous discussions. Today I will gonna discuss the qualifications for obtaining the industrial design under the Industrial Designs Act. My dear viewers, there are two important qualifications that are required to be proved, or you can say required to be met for a design to be protected under the Industrial Designs Act. The first one is that the design must be the subject matter under the Industrial Designs Act for the protection, and there must not be a subject matter of a nature which is excluded explicitly by purview of the Industrial Designs Act. Only then it can be protected under the Industrial Designs Act, otherwise it will get rejected. I would also discuss the exclusions in today's discussion as to what all has been excluded by purview of the Industrial Designs Act, which can never be given the protection under the Industrial Designs Act, because that subject matter, irrespective of the fact that it may be a design or it will fulfill other qualifications, but it shall not be registered because it has been explicitly excluded under the Designs Act of 2000. My dear viewers, the second requirement to be met for obtaining the protection under the Industrial Designs Act is that it must be new or original. That new or original requirement is a sine qua non for obtaining the design protection. If the design is not new or original, it shall not be registered. My dear viewers, you must be now recalling that in the Patent Act 1970 we discussed the requirement of novelty once. The requirement of novelty is different vis-a-vis to the requirement of new or original under the Designs Act. It is a requirement under the Designs Act. Novelty requirement was a requirement under the Patent Act, and there lies a lot of difference between both the requirements, technically as well as substantially, or you can say in the context of the design law, the requirement of new or original has been given a different connotation legislatively as well as judicially. So, we will see both the connotations as determined by the courts in many case laws, etc., and legislative interpretation we will also consider today in our discussions. So, if the design is not new or original, it shall not be registered. My dear viewers, one more requirement which is rarely discussed or is generally not discussed, you see, but it is one of the most important requirements for obtaining the design protection. That is about, you see, the appeal in the end product. While discussing the definition in the previous discussion or in the previous discourse, I told you that if there is no appeal in the end product because of the application of the design to an article, then that particular design might not get registered. My dear viewers, it is a sine qua non because aesthetic appearance or a visual element is being protected under the Designs Act. It is the visual element or the aesthetic appearance of the design or its application on an article is protected. The design law does not give any protection to the functionality or to the substance as such. It just gives a protection to the visual elements or to the appearance. So, the appeal to the eye or an aesthetic appearance of the product is also one of the most important requirements for obtaining the protection under the Designs Act. Let me take you to the registrable designs. As I said that new or original designs are protected under the Industrial Designs Act. If you look at the requirements on the left hand side of on the screen, you will find that novel word is written, because you see we use novel word interchangeably with the new. So, verbatimly or as per the legislation, the word used by the legislation is new or original, it is not novel, but I have used it for the purposes of bringing brevity to the expression. So, that is why, and even the courts are using the word novel very frequently and very often. So, there is no as such difference that is being considered, but in terms of looking at the word novelty in the context of the patent law and new in the context of the design law, both the terms have different connotations and both the terms are different, of the different purview or of the different purport. So, my dear viewers, novel or original designs can be given the protection. The definition of the word original includes, or the definition of the word original defined under the Industrial Designs Act even encompasses that all designs can be given the registration under the Industrial Designs Act if they have been given a new application. I will make you understand as to what does this new application mean, but mind it that even old designs can be given the protection under the Industrial Designs Act, even they have existed earlier, they are into the publication, they are into the use, etc., still they can be given the protection if they have the new application. Old features can also be given the design protection if somebody has come up with a new combination of the old features and has applied those combinations accordingly, then those new combinations can also be given the design protection under the Industrial Designs Act. My dear viewers, it is necessary to sufficiently impart novelty to the whole article or to the whole design. If the applicant fails to do that, then in that case the design shall not be registered. I will discuss all the parameters mentioned on your screen one by one in little more details later. I will now come to what, that there are certain things which shall not be given the registration under the Industrial Designs Act. Non-functional designs, you see, as far as the functionality is concerned, my dear viewers, is a component of the Patent Act, or patent protection lies with the functional things. So, the design for fetching the protection under the Industrial Designs Act should be non-functional or must be non-functional. If it is functional, then it will become a subject matter of the patent protection. Similarly, my dear viewers, it must not act as a trademark. The function of the trademark is different. It is to indicate the source or origin of the product. The function of the design law is to give the aesthetic appearance or give some visual appearance to the end product. So, the design must not be a trademark, must not be functional, it has to be novel or original for fetching the design protection under the Industrial Designs Act. Simultaneously, there is one more thing that has to be there, that it must not be an artistic work under the copyright law. If it is an artistic work under the copyright law, then it shall be protected under the copyright law. There is an overlap between the subject matters of the design, of the copyright, of the trademarks, which we will discuss in detail today. Let me now take you to the prohibitions for registration of certain designs. In the first part, I have discussed the different requirements for obtaining the design protection. Let me just recapitulate quickly before I take it up. It has to be novel or original, it has to be non-trademark, non-artistic work, non-functional, only then it shall be given the registration. Now, let me take you to the prohibitions of registration of certain designs. My dear viewers, according to section 4 of the Industrial Designs Act, a design which is not new or original or has been disclosed to the public anywhere in India or in any other country by publication in tangible form or by use in any other way prior to the filing date, or where applicable the priority date of the application for registration, or is not significantly distinguishable from known designs or combination of known designs, or comprises or contains scandalous or obscene matter, shall not be registered. My dear viewers, let me tell you that you see, section 4 says categorically that any design which is not new or original shall not be registered. So, we have read and we have seen that novelty requirement and the originality requirement is the sine qua non, is a prerequisite for obtaining the design protection. By purview of section 4, these prohibitions have been explicitly mentioned in order to make it clear that the design which is not new or original shall not be registered. A design which has come to the public use, has come into the publication, has already fallen into the public domain, or is being used in India or otherwise anywhere in the country or in other country for that matter, or which is you see in some manner or the other in a tangible form has become usable, has been seen or perceivable by any person, then that shall not be registered. These are some of the prohibitions for obtaining the design protection. Simultaneously, it says a design shall not be registered if it is not significantly distinguishable from known designs or combination of known designs. So, for example, my dear viewers, that there exists one design and tomorrow somebody applies that same design on any other article, then that application of the old design in the new manner has to be significantly distinguishable from the known design or combination of known designs. If it will not be significantly distinguishable, then it shall not be registered. My dear viewers, we also see that if a design is scandalous or obscene, then it shall not be registered at all. We have seen the similar requirement of being scandalous or obscene in the trademark law as well. Even the trademarks which are scandalous or obscene, they are not registered under the Trademarks Act 1999. So, this requirement which is premised on morality, on social order, etc., is to be upheld, and no design which is scandalous or obscene shall ever be registered under the Industrial Designs Act. Well, my dear viewers, let me now take you to what the requirement of new/novelty in design law. What does this new or novelty in design law mean? Viewers, the novelty has to be judged by the instructed eye, or it has to be judged by the naked eye. If there lies a novelty in the application, even in the application, I am not saying that the design is altogether new. The design is an old design, but it has been applied in a novel manner on an article. Its application seems new or is new, then that is becoming novel or new for the purposes of the design law, or original for the purposes of the design law. And that novelty must be judged by the instructed eye, must get clearly perceivable by the instructed eye. It must not be such work which has been published anywhere in India or abroad for that matter. Nowadays, my dear viewers, since we have a system of international filing, so even if the design has been published elsewhere, not in our country, but through the international filing application system, the applicant has filed the design protection of the similar application in India within 6 months of the time period, then in that case even that publication will be construed as publication and the design will not be any more novel in that case. I will give you some case studies in the end of this today's discussion, and will apprise you about prior publication anywhere in the world and in India. My dear viewers, for a design to be novel, it is necessary that it is not registered anywhere prior to the registration in question. If it is registered anywhere in the world, then it shall not be given the registration in India, because we follow certain international instruments, international conventions, and we being the signatory of those conventions and instruments are supposed to abide by those, and we can never ever deny the registration or uphold the right of that person in our country merely on the pretext or merely on the ground that this person is registered in any other country, not in India. Since it is an international filing system, and by opting the international filing system, my dear viewers, applicant may register the design in many nations by paying the fee respectively in different jurisdictions by a single application. Well, as far as the novelty is concerned, for determining the novelty or newness in the design, it is to be proved that it has not been anticipated, anywhere in respect of that class of article to which it applied. It has to be proved only in respect of that class. You might find an instance where a design has been applied on any other class. So, if it has been applied on any other class, then you can still hold a good chance of getting the design protected under the Industrial Designs Act, because your design is referring to a application on a different class of article. You are not aspiring to apply it on a class of article over which it has already been applied previously in the country or elsewhere in the world. So, my dear viewers, you have to keep it in mind that the design is protected for a specific class of article to which it is applied. You have to be very careful in choosing the class. The classification system is to be seen, and out of that classification system, the applicant has to make a specific choice and informed choice as to where he wants to register, or under which class or for which class or against which class he wants to register his design for that particular article. If he fails to do it carefully and meticulously, then that may be problematic in the future. So, my dear viewers, in respect of that class of article, you get the protection, not in respect of classes or other classes of other articles available in the classification system. Now, let me proceed ahead and tell you that any innovation or improvement of a design can also be given the protection, but it must also prove the factum of novelty or originality in it. An innovative or an improvement in design, or an innovation or an improvement in design might stand a good chance for getting the protection afresh, but the requirement of novelty oblique originality is needed to be proved. If it fails to do that, if that improved version of the design fails to do that, then that shall not be given the registration under the Industrial Designs Act. Well, my dear viewers, it is also to be noted that the application of the design on a new article done by you must be substantial one. If it is not substantial one, then you may not get the design protection. Suppose you have applied the design, which is an old design, on a new article. There is an instance where the earlier design was of what? A toy in the form of a teddy bear, but now the new applicant has found a new application of the old design of teddy bear on a school bag. So, this example on your screen is very helpful to understand that a old design of a teddy bear, which used to be on the toys, now is being applied on what? On school bags. So, this application proves that the person has applied his creativity, has applied his mindset, has applied his intellect to apply this design on this new article. That much is sufficient to prove that the person will gonna get the protection, and that much is sufficient to prove that this design is registrable under the Industrial Designs Act. So, let me just quickly and briefly sum it up, that the design to get the protection has to be new or original, it must not be scandalous, it must not be obscene, it must not be functional, it must not be an artistic work, it must not be a trademark. For a design to be protected under the Industrial Designs Act, it has to be proved that it is a new or a novel work, and it is a case where you see it has been applied on an article. There may be a situation where an old design is being applied on a new article, even that situation is a qualified situation to be given the design protection under the Industrial Designs Act. Now, let me take you to the test of novelty, my dear viewers. As far as the test of the novelty is concerned, the test for the novelty is primarily the test in the form of instructed eye, or judged by the eye by the person. If you see a design and its application on article, then your eye must discern and comprehend that appeal, or your eye must comprehend that particular aesthetic appearance that has come to that article because of the application of that design. If it is not coming, then the novelty fails, the another test which is more of a objective in nature, unlike the previous which is subjective in nature. The objectivity lies where, you see, if the design has already been published or is anticipated or is being in use anywhere, then that design shall not be registered, my dear viewers, because it is easy with the help of the recent databases and with the help of the search engines to find out that the design is either published somewhere else or is in use or anticipated. Then that kind of a design does not fulfill the requirement of novelty and it shall not be given the registration. Now I am coming to the requirement of originality under the design law. My dear viewers, as provided under the definitional clause by purview of section 2 sub clause G, original here means in relation to a design, any design originating from the author of such design, and it also includes the cases which, though old in themselves, yet are new in their application. I would request all my viewers to pay a very keen attention to this particular definition of the word original, because this is not a simple definition. It in the first limb says that design will be original when it originates from the author of such design. So, when does it originate from the author of such design, my dear viewers? The common understanding is that the design is deemed originated from the author of the design if it has not been substantially copied by him, or if its application has not been substantially copied by the design applicant. If it has been found that the applicant has copied it from somewhere, or he has copied the application or the manner of application of the design, then it is deemed not to have been originated from the author. The next limb of the definition on your screen, my dear viewers, talks about what? It says that originality will lie even in those old designs which see a new or a novel application on articles, because cases which, though old in themselves, yet are new in their application, have been included in the definition of the original. I have given you an example of a teddy bear shaped bag, where you see old design of a teddy bear is being applied to a school bag, not on a toy or not in a conventional manner on a toy. So, this new application of a old design is also fulfilling the requirement of originality and is becoming original. So, my dear viewers, both the limbs of this definition on your screen are very important, because on the basis of these two definitions, the definition of novelty or originality, we proceed ahead and see further things as far as the design protection is concerned under the Industrial Designs Act. Now, we have some more information on the originality. It is generally understood, originality is generally understood that it is something that has come for the first time or is created for the first time, has not been created before by anyone, or it is first time in the formation of it. But my dear viewers, since the definition has made it clear, aptly clear, that even old designs, when they see the new application, are fulfill the requirement of novelty. So, this conventional understanding or this orthodox understanding of originality, that design which has not existed earlier will be only the original design, that gets completely dispelled, or you may say that understanding must get completely ousted in this situation. Now, let me take you to the exclusions, my dear viewers. After discussing with you the protection requirements and the requirements or the prohibitions of certain industrial designs for the protection, I am coming to the exclusions as given under the Industrial Designs Act. My dear viewers, as far as the exclusions are concerned, all the exclusions have been categorically written under the Industrial Designs Act, and there is no such ambiguity or vagueness in interpreting these exclusions. but at times some difficulties are being faced in order to interpret the exclusions. So, let us see quickly the exclusions. The first exclusion under the Designs Act, when I say exclusion, I mean to say that a work shall never be registered under the Industrial Designs Act if it has been excluded by purview of the Industrial Designs Act. So, any method or principle of construction, my dear viewers, is excluded from the purview of protection under the Industrial Designs Act, because these are the things which must not be given in the form of a monopoly to anyone. A person may have a protection on a design of a building. It may be a artistic work of that person, it may be a blueprint in the form of artistic work of that person, but that person will never be able to get the protection on the method of construction or on principle of construction. Similarly, shapes which are dictated solely by function shall never be given the registration under the Industrial Designs Act, because they are excluded. When we say shapes, my dear viewers, let me tell you, shapes are very well registered or very much registered under the Industrial Designs Act, but those shapes which are dictated solely by function, they shall never be registered. Otherwise, there would be a difficulty in differentiating between patent subject matters or the industrial design subject matters. It will become really very complicated and nothing will be given the protection in that case. So, there must be a clarity in the discourse that shapes which are dictated solely by function must not be given the registration, or which have a mechanical function, they must not be given the registration. Otherwise, all other shapes are allowed to be given the registration and can be given the registration. My dear viewers, as far as the shapes are concerned, we have seen that shape marks can be given even trademark protection. Shapes can even be given a trademark protection. We have been discussing about the trademark protections to be given to the shapes. For example, a Pepsi bottle, my dear viewers, is protected under the Trademarks Act 1999. The shape of our Pepsi bottle is protected under the Trademarks Act 1999. So, it is little confusing to determine as to where to go, I mean under which particular legislation of the intellectual property one should get the shape protection. My dear viewers, it is always advisable that one should thrive for the maximum protection in terms of number of years for the protection. So, the maximum protection that one gets is under the Trademarks Act 1999. One does not get the maximum number of protection under the Industrial Designs Act. So, it is advisable that one who thinks that his shape is acting as an indication of the origin of this product or acting as a trademark, then he must get it protected under the Trademarks Act 1999. He must not try to get it protected under the Industrial Designs Act. But shape can be given a protection under the Industrial Designs Act, but I was discussing the exclusions and I was telling you that those shapes which are dictated solely by function or which are mere mechanical devices, those shapes are excluded and shall never be given the protection under the Industrial Designs Act. So, applicant if is approaching the controller of patents and designs for the protection of the shape, he must keep it in mind that his shape must not be dictated solely by the function, or it must not be a mechanical device. If it is a mechanical device or if it has got a functionality, then it must be given the protection under the Patents Act. My dear viewers, let me give you an example of a toothbrush or of a shape of a toothbrush. We use toothbrush of different shapes and we see that different shapes of toothbrushes are primarily for giving the visual attraction of the toothbrush, but there are certain toothbrushes available in the market and those toothbrushes are of unique shapes, and those unique shapes of those toothbrushes, my dear viewers, are meant to serve some function. Either it has got some therapeutic function or it has got some function in it, involved in it. So, that particular shape, that later shape of a toothbrush having a function, be it be a function to give you more effectiveness in terms of cleaning your teeth, etc., that must not be given the protection under the Industrial Designs Act. Industrial Designs Act, I am emphasizing it again, reiterating it, is given only to those designs including shapes which are giving some aesthetic appearance to the end product after the application of that design on an article. It is not given on any other parameter, my dear viewers. So, that is why you see there are certain things which are excluded from the purview of the Industrial Designs Act to be given the design protection, notwithstanding that they are designs. Now, I will take you to some more exclusions. Any trademark under the Trademarks Act is also excluded to be given the design protection. As I have told you and discussed with you earlier, that a trademark serves a very different function than a design. So, a trademark should be protected under the Trademarks Act, not under the Designs Act. Similarly, artistic works are protected under the copyright law, they are not to be protected under the Industrial Designs Act. Then we have some more entries in the exclusions. Any property mark under 479 of the IPC should not be given the protection under the Industrial Designs Act. My dear viewers, under Indian Penal Code by purview of section 479, property marks are given protection, and if anyone is found using anyone's property mark, then it becomes a penal offence under 479. So, my dear viewers, such property marks which are declared or which are delineated under the Indian Penal Code as property marks must not be given the protection under the Industrial Designs Act. It has been reiterated by purview of the Designs Act in the exclusions also. Then we have another entry that the color per se is not design and can form part of design. My dear viewers, we have seen that some people do come up with color combinations for getting the protection. They do devise some color combinations which are very unique, which are attractive, which are tempting, which looks very fancy, but still you see it is very difficult to get the protection on those color combinations under the Industrial Designs Act. As far as the trademark law is concerned, the color combinations can be given the trademark protection. A color as such exclusively cannot be given a trademark protection, but the combination of colors, say a combination of white and blue of a Pepsi, or a combination of red and white of a Thumbs Up or Coca-Cola, these are the combination of the colors. These combinations can be given the protection either under the Trademarks Act if the purpose of a color combination is to indicate the source, or if the purpose of the color combination is to give an aesthetic appearance to the end product, then it has to be protected under the Industrial Designs Act. But color per se is not design, my dear viewers. It becomes a design or a tenable matter to be given a design protection under the Industrial Designs Act when it is applied to an article by making a mixture of it or by some combinations, otherwise it shall not be given the registration. Then we have some more you see important slides with us, my dear viewers. I will take you to those slides later. After these exclusions, I would like to discuss with you the overlap, because we have come to that stage where we can certainly look at what? We can certainly look at the overlap of the designs with the overlap of the subject matter of designs with the trademark and copyright, because in the copyright law artistic works are given the copyright protection, and those artistic works may also get the design protection under the Industrial Designs Act. Under the trademark law, color combinations, shape of goods, these two subject matters are common with the Industrial Designs Act, and they can be given the industrial design protection also. So, my dear viewers, you see there is an overlap undoubtedly, but that overlap has got what? It has got a redressal, or you may say that it has got a some balanced approach as far as its application is concerned. When this overlap is seen by purview of a point of view of a academician or by purview of a practitioner of law, I must say that generally people do confuse with what? They do confuse in this, that whether they should go for the protection under the trademark law, under the design law, or under the copyright law. I would pitch in for what? I would pitch in to, and I would urge to all the applicants who are under these confusions to always go for the protection under the trademark law, because that gives you a perpetual protection. It does not give you a limited protection like copyright and design law, because in the design law the protection lies only for the 15 years maximum. Now, let me tell you that when it comes to the overlap between the copyright law and the design law, in the Copyright Act 1957 there is one section, that is section 15 of the Copyright Act, which clears the passage, or you can say that clears the doubt as far as this overlap is concerned. Section 15 of the copyright law, my dear viewers, says that I am taking you to the section 15 quickly to have a look at the language of section 15, because section 15's language is very important as far as this discussion is concerned, without which you will not be able to understand this issue at hand. See the definition provided on your screen of section 15. It is a special provision, my dear viewers, regarding copyright in designs registered or capable of being registered under the Designs Act. Well, as the language is aptly clear that it is a special provision regarding copyright in design registered or capable of being registered under the Designs Act 1911. My dear viewers, it in its first subsection reads that copyright shall not subsist under this act in any design which is registered under the Designs Act. So, it means that when a design is liable to be protected or bound to be protected or is capable to be protected under the Industrial Designs Act, no copyright shall ever subsist in that design under the Copyright Act, not at all, because it is something which is liable to be protected under the Designs Act. Further, if you look at the subsection 2 of section 15, it reads that copyrighted design which is capable of being registered under the Designs Act, but which has not been so registered, shall be given the registration under the Designs Act. My dear viewers, this section 15 of the copyright is a section which is talking about the 1911 Designs Act. Now, we have a Designs Act of year 2000, which says that a design shall cease as soon as an article to which the design has been applied has been reproduced more than 50 times by any industrial process by the owner of the copyright or with his license by any other person. Let me give you an example of this particular clause or this particular subsection of section 15. It says that any subject matter which is liable to be protected under the Designs Act shall never get the protection under the copyright law if it is something which is to be given the protection under the design law, but has been reproduced for more than 50 times. If somebody has reproduced it for more than 50 times, then in that case a copyright over that particular work shall cease to exist. No copyright shall ever be available. If somebody does not make 50 copies of it, say makes only 49 copies of it, then the right in the form of a copyright over that particular subject matter shall not cease. Let me give you an example of an apparel industry where most of the renowned, you see, designers of celebrity apparels, etc., they prefer to produce only 49 copies. In majority of the cases, they never go for reproduction of more than 50 times, because they always aspire for copyright protection on their designs or on their apparel designs. They never prefer industrial design protection. And why they do not do so? Let me tell you and let me make it very clear that copyright protection is long protection. It comes to you for the whole of life plus 50 plus years after the death of the person. So, why would not they prefer, when they are able to appropriate the returns only by reproducing 49 numbers of that particular work? But on the contrary, my dear viewers, if we take an example of a normal designer, not so renowned, not so prominent, or not working for the celebrity apparels, etc., then in that case you will find that they always prefer to have the design protection under the Industrial Designs Act. They do not prefer to have a protection under the copyright law, because they do not want the copyright, they do not want the copyright protection, they want the design protection for 15 years. With the design protection, there does not come any bar in the form of reproduction in terms of numbers. Anyone can, you see, after obtaining the design protection, make as many number of copies as he wants. There is no embargo as far as the number is concerned of the copies. But if somebody is aspiring for the copyright protection, then my dear viewers, the copyright over that work shall cease to exist or subsist if the number increases 50 of that particular application of the design. So you have to be little careful in choosing either of these two protections, the copyright and the design protection. I would say that those who think that their work is so popular and so prominent and so renowned that they will be able to appropriate their returns through the royalties in mere 49 copies, they must always go for the copyright protection. But those who think that they need to make as many copies as are possible for them to make the appropriate returns or adequate returns, they must aspire for the design protection, not for the copyright protection, because copyright law balances it. This overlap has been balanced by purview of section 15 by categorically mentioning that the copyright in that design shall cease to exist if that design is liable to be protected under the design law, and if it has not been done so. That is all as far as the overlap of the copyright and the design law is concerned. And as far as the overlap between the trademark law and the design law is concerned, I have already told you that shape trademarks is the only situation where there lies a possibility of some overlapping, but that is also to an extent balanced, because generally people do prefer to have a protection in the form of a designs act over the shapes, but when their shapes are being used by them to indicate the source, they prefer to go for the trademark protection. Now my dear friends, we have come to the juncture where we must see the different case studies on such aspects or on such important aspects of the design law. I have a case at hand right now, which is very popular case. There are very few cases available as far as the industrial designs is concerned of the Indian context. Out of those few cases, this one is very important of year 2008, that is Bharat Glass Tubes Limited versus Gopal Glass Works Limited. My dear viewers, in this case the question was on the new and original and on the lack of evidence of new and original of the particular design. My dear viewers, let me tell you the brief facts of this case quickly. In this case, my dear viewers, the respondents, that is Gopal Glass Works Limited, they registered their design for diamond shaped glass sheets under the Designs Act 2000. They registered their design for diamond shaped glass sheets under the Designs Act 2000. Now you see, diamond shaped glass sheets can be applied to glass, can be applied to plastic, or it may be applied to any other stuff also. So this is a shape on which they registered their design in the beginning, and it was in respect to what? It was in respect to, directly in respect to the glass sheets. Mind it that they got it registered for that one particular class, that is glass sheets. They did not get it registered for any other class. Had they registered it for any other class, the situation would have been different here. Since they have categorically mentioned in their application that they are registering it for the glass sheets, that diamond shaped design would be their exclusive right to be applied on those glass sheets by them exclusively in India. My dear viewers, let me give you a few more facts as far as the respondents are concerned. These respondents took the engraved rollers from the German company and they started using those engraved rollers for the application of that diamond shaped glass sheets on the glass sheets manufactured by them. Well, it is important to note here that the engraved rollers were of a German company, but the German company gave them all the rights on those engraved rollers. They said that as far as the application of the design this particular diamond shaped glass sheet design is concerned, you are the exclusive person in India to use these engraved rollers to apply the design on the glass sheets. When the situation is such where they are having an exclusive right through the German company for the application of those diamond glass sheets on glass materials by them, no other company must use that ideally. But one fine day, my dear viewers, they found that appellant has started using their shape or their design, that is diamond shaped glass sheets, and they started applying on some other works. Basically, the respondents acquired the sole right, we understand that, but the appellant started marketing these glass sheets with the same designs. Now let me tell you, respondents had the exclusive right from the German company to apply those engraved rollers or to use those engraved rollers for the purposes of applying that diamond shaped glass sheets on their sheets. But on the other hand, they found that the appellant started marketing their glass sheets with the same design in the market. Now it has become a matter of contention between these two parties. One party having already been using the diamond shaped glass sheets, or making or manufacturing the diamond shaped glass sheets, or you can say technically has already been applying the diamond shape on the glass sheets with the engraved rollers with the permission from the German company, finds it that some other appellants are using it in India and they are marketing as if they are their own products. Now it is very difficult for the court to decide or for the controller to decide a situation, because of the fact that now in this situation it would be seen who is the earlier user of that design. It is a fact based situation where it can be found out that the fact clearly demonstrates that respondents are the earlier users, because they took the permission from the German company, they took the engraved rollers from the German company, they started using those engraved rollers for application of those diamond shape on the glass sheets manufactured by them. So respondents were encroaching on their rights. It is a fact based situation. But as far as the new and original requirement is concerned, because the appellant in this case alleged against the respondents that they are not coming to the controller with the clean hands. In fact, they have also not created this design, and their design is not new and original. It is a design of a German company which is published also in the year 2008 in UK's patent office website. The evidence of the same was also provided to the controller of patent and design in this case, that it is a design which is already published, and the publication's evidence is available by referring to the UK patent office website, where the design lies vis-a-vis to the German company, or the document relevant document in that regard clearly says that it is a design of a German company, not of a Indian company called Gopal Glass Works. My dear viewers, now our understanding, theoretical understanding which we discussed today in the beginning of this lecture, will be of immense help for us to decide this case. We have seen in our discussions today that even if the design is old, but its new application can make it a qualified design for the protection of the design under the Industrial Designs Act. So in this case, if the respondent wants to defend themselves or their case, they have to prove that it is the old design of a German company which has been applied by them on a new article for the first time, or it is a new application of the old design. Once they will be able to prove it, I am sure that they will gonna get the defense, and this is what happened in this case. Though initially they faced the hardships because the Controller General of Patents did not find their argument convincing. They found the argument or contentions of the appellant more convincing, and they restricted or passed the injunctions against the Gopal Glass Works to further use that design. The Assistant Controller of Patents found merit in the appellant's contention, and they found that the respondent's design was not new or original. since the German company had been manufacturing the engraving rollers with the same design since 1992, and the evidence of the same is available on the UK Patent Office website. Now it has become a very complicated situation, my dear viewers, where on the one hand you see they are saying that irrespective that it is a new design, we assume and we admit that it is an old design, but we are applying it in a new article. So as far as the definition of originality provided under section 2 clause G of the Industrial Designs Act is concerned, it is categorically clear that even if it is an old design but applied on a new article, it fulfills the requirement of getting the registration under the Designs Act, but it has to be proved that it is a new application and it is a permitted application. If they fail to prove it, if the respondents fail to prove it that it is a new application, then it will be difficult for them to sustain in this case. Now let me take you to what? The counter arguments raised here by the respondents. The respondents countered by pointing out that the German company manufactured only the engraved rollers and not the glass sheets, and it is the Gopal Glass Works who are making the glass sheets by using these engraved rollers of a diamond shape. So it is becoming a very clear cut case of a situation where old design is being applied to a new article for the first time by a new person called Gopal Glass Works in this case. So once they will be able to prove it, it will be easier for them to get the relief. But the hurdle that they faced, my dear viewers, in this case was that the appellants contended that look, since it is published in UK's Patent Office website, so through that publication it must be deemed that it is no more new or original for the purposes of the Design Act. Now it becomes crucial to invoke section 19(1)(a) and 19(1)(b) to understand it fully. My dear viewers, let me tell you that section 19(1) says, 19(1)(a) specifically says that any design to be called a new design, it has to be a design which has not been published earlier, which has not been anticipated earlier. If it has been published or anticipated earlier in India, then it shall not be new or original design. But mind it, my dear viewers, under 19(1)(a), word in India is used. So any design which is published elsewhere than India, then it is no more a disqualification for that design to get a registration in India under the Industrial Designs Act by becoming a new design for the purposes of the Industrial Designs Act. Now the court was confronted with this question, my dear viewers. The matter went to the High Court later, and High Court reversed the order of the Assistant Controller of Patents, and wherein High Court found that 19(1)(a) is explicitly saying that anticipation is to be gauged and assessed only by referring to the designs which are published in India, not otherwise in India. So any design which is found published elsewhere in the world, then that will not be of any hurdle, that will not be of any sort of obstruction for a applicant to get the registration of that design. My dear viewers, another important aspect or facet of this particular case was that originality has, the definition of the originality as provided under 2(1)(g) is also makes it aptly clear that even if it is an old design but applied on a new article with the permission of a company making those dies, or you can say engraved rollers etc. for the application of those design, it is allowed. One can easily get the protection unless it is not published in India. The moment it is proved that it is published in India, then even that application will be not possible. So that is it for the day, sir. Thank you very much, my dear viewers.